I folded my hands on the defense table and counted the grain lines in the wood. 17. I counted them twice. Across the aisle, my brother-in-law was dabbing his eyes with a handkerchief that looked freshly pressed, telling the judge that I had been slipping for years, that I had manipulated a dying woman, that I was not in any fit state to be trusted with her estate. His wife, my older sister, sat beside him with her hand on his back, nodding like a metronome. Have you ever sat in a courtroom and watched the people who were supposed to love you stand up, one after another, and swear under oath that you are a liar, a thief, and probably losing your mind? I have. And the strangest part wasn't the anger. It was how quiet everything became inside my head, like someone had finally turned the volume down on a television I'd been forced to watch for 8 months. My name is Adeline. I'm 31. I work as a forensic auditor for a mid-sized firm in downtown Providence, and 6 months before that courtroom, I had buried my mother in a cemetery just outside Warwick, Rhode Island. The headstone reads, Margaret Rose Holloway, 1952 to 2025. I picked the font myself. I picked the flowers. I picked the suit she was buried in because my sister said she was too overwhelmed to go to the funeral home, and my brother-in-law, Dr. Preston Keene, said he had back-to-back surgeries that week. They weren't too overwhelmed to read the will. Let me go back. My mother raised my sister Colette, and me mostly on her own, after our father walked out in 1998. She was a pediatric nurse. She worked night shifts, then came home and made pancakes shaped like bunnies because she thought it would make us forget she'd been gone. Colette is 8 years older than me. By the time I was 10, she was already gone college, then nursing school, then a residency program in Boston where she met Preston. He was a third-year orthopedic resident from a family that summered in Nantucket and used the word summered without irony. Colette married him when I was 16. At the wedding, he called me the little sister and patted my head like I was a retriever. I loved my mother. I want to be very clear about that, because everything that comes next only makes sense if you understand that. I loved her the way you love a person who taught you how to tie your shoes, how to read a prescription label, how to apologize when you've been wrong. I was the one who drove her to her oncology appointments at Rhode Island Hospital. I was the one who learned to change her dressings. I was the one who slept on her couch for the last 3 months of her life so she wouldn't wake up alone. Colette called twice that whole time. Preston never called. My mother died on a Tuesday morning in March, a little after 6. She squeezed my hand and said my name, and then she was just gone, the way people go when they've been tired for a long time. I sat with her for another hour before I called anyone. I called my sister first. She said, Oh, Addie. And then 30 seconds later, she said, Do you know if she updated the will? That was the first time I understood. The second time was at the reading of the will, 9 days later, in the office of my mother's attorney, a man named Harold Briggs, who had known our family since 1989. My mother had left the house in Warwick, her retirement accounts, and a life insurance policy to be split equally between Colette and me. Fair, expected. And then she had left something else, a separate trust, funded by a settlement from a medical malpractice case she'd won against a hospital in 1994, back when Colette and I were little, and she'd almost died from a misdiagnosis. That trust had grown for 31 years. It was worth, as of the reading, about $3.6 million. She had left that entire trust to me, not to punish Colette. The letter attached explained everything. My mother wrote that Colette had Preston, and Preston had family money, and the house in Providence, and the summer place, and the college funds for their 2 kids. My mother wrote that she worried about me because I had chosen a quieter life, and because I had been the one who stayed. She wrote that she wanted me to have a cushion. She wrote that she hoped I would use it to finally buy a place of my own, and maybe take the trip to Kyoto I had been talking about since I was 22. Colette went white, Preston went red. Harold Briggs kept reading. By the time we left the office, Preston was already on his phone. 2 weeks later, I got served. The petition was filed in the Rhode Island probate court. The gist of it, in the soft legalese lawyers use when they want to destroy someone politely, was this. Adeline Holloway had exerted undue influence over a dying, medicated, cognitively impaired elderly woman. Adeline Holloway had isolated the decedent from her other daughter. Adeline Holloway had possibly forged or coerced the signature on the trust amendment dated January of that year. And this was the part that made me actually laugh out loud when I read it. Adeline Holloway was herself emotionally unstable, with a documented history of erratic behavior and possible undiagnosed mood disturbance, as attested to in a letter attached as Exhibit C. Exhibit C was signed by Dr. Preston Keene, MD. My brother-in-law had written a 1-page letter on his hospital letterhead describing my affect during our mother's final weeks. He wrote that I had been visibly dissociative, emotionally labile, and exhibiting signs consistent with a possible manic or hypomanic state. He wrote that, in his clinical opinion, I was not a reliable narrator of my own mother's wishes. Preston Keene is an orthopedic surgeon. He replaces knees. He has never, in his entire career, treated a single psychiatric patient. He had not examined me. He had not spoken to me in more than 4 months. The last conversation we'd had was at Thanksgiving, when he asked me to pass the cranberry sauce. I read the letter 3 times. Then I read the rest of the petition. And then I sat down at my kitchen table, opened a new spreadsheet, and started to work. See, here is the thing my sister and my brother-in-law did not know, or did not care to remember. I am a forensic auditor. My entire job, 8 hours a day, is to follow money through systems that are specifically designed to make it untraceable. I trace embezzlement. I testify in court about it. I have put 3 people in federal prison. They thought they were suing a grieving younger sister. They were suing the wrong person. I could have hired a lawyer that week, filed a countersuit, and tried to settle. That's what a rational person would have done. But I wasn't feeling rational. I was feeling something colder than that, something that had been building since my mother's funeral, when I watched Colette cry beautifully for the cameras of her in-laws, and then check her phone during the eulogy. I wanted more than to win. I wanted to understand exactly what they had done, and I wanted a record of it, and I wanted to hand that record to a judge in a way that could not be explained away. So I hired a lawyer, a woman named Priya Mehta, who had handled a case adjacent to one of mine 2 years earlier, and I told her to slow walk everything. Take the extensions, delay the depositions, drag it out. And in the meantime, I went to work. The first thing I looked at was the power of attorney Colette had held for our mother in the last 11 months of her life. Our mother had signed it during her second round of chemo, when she was exhausted and scared and wanted someone to be able to pay her bills if she couldn't. She had signed it at the kitchen table, with me on one side and Colette on the other, and I remember telling my mother she didn't have to, and my mother patting my hand and saying Colette was a nurse. Colette understood hospitals. It was fine. I pulled the bank statements. I had authorization as the executor of the estate, so this was legal. I pulled every statement from every account my mother had held for the last 3 years. I sat at my kitchen table with a yellow legal pad and a red pen, and I went line by line. In the last 11 months, my mother's main checking account had been drained of $142,000 in withdrawals and transfers I could not tie to any of her normal expenses. The withdrawals were not large enough to trigger automatic reporting. They were staggered. They were labeled with vague memos: home repair, medical supplies, caregiver. But my mother had no caregiver she paid out of that account. I was her caregiver. And I was not paid. I kept pulling. Colette had also been a signatory on a money market account my mother used as a secondary savings. That account had lost another $81,000 over the same period to 3 outgoing wires, 2 to an LLC in Delaware called Nantucket Legacy Holdings, and 1 to a private pay invoice from a concierge medical practice in Boston called Keene Family Wellness, which it turned out did not appear to have any actual patients, any actual staff, or any actual address beyond a suite number in a building that also housed a UPS store. Keene Family Wellness was registered in the state of Massachusetts to Dr. Preston Keene. I stared at that line item for a long time. Then I made myself a cup of tea and I kept going. For 5 months I went. I did not confront them. I did not tell Priya everything I was finding. Not yet. I answered their discovery requests slowly and politely. I let Preston submit a supplemental affidavit in which he now claimed, under oath, that he had informally evaluated me during family gatherings and had grave concerns about my mental state. I let Colette give a deposition in which she wept about how hard it had been to watch me take over during our mother's illness, how she had wanted so desperately to be more involved, but I had pushed her away. I sat through the deposition. I did not react. Priya passed me a note that said, "Just breathe." What Colette and Preston did not know was that I had already subpoenaed 3 years of records from Nantucket Legacy Holdings. I had already cross-referenced the dates of the wire transfers against Preston's public surgical schedule at his hospital, so I knew when he had been in the OR and when he had been, say, in Delaware signing papers. I had already found the LLC's registered agent, and through him, the 2 other shell companies Preston had used to move the money around. I had found the payments he had routed through those shells to a jeweler in Boston, to a yacht broker in Newport, and to a contractor in Nantucket who was, at that very moment, renovating a guest cottage on a property my sister did not know her husband owned. I'd also found something else, something that changed the case from a family dispute into something a federal prosecutor might want to hear about. But I was saving that. I kept one more thing for myself. During those 5 months, I went to my mother's grave every Sunday. I took her favorite flowers, peonies when I could find them, white roses when I couldn't, and I sat on the bench near her headstone and I talked to her. I told her what I was finding. I told her I was sorry it had come to this. I told her that Colette had been her daughter too, and I knew she would have wanted me to be gentle. I told her I was going to be gentle, right up until the moment I wasn't. The hearing was scheduled for a Thursday in October. The courtroom in Providence was small, wood-paneled, with a window that looked out onto a parking lot. Judge Eamon Fitzwilliam presided. He was in his late 60s, silver-haired, with the kind of face that had heard every excuse a human being could produce. Priya told me he did not like theatrics. I told her that was fine. We had not come to be theatrical. Colette's attorney went first. He laid out their case in broad strokes. A grieving family, a troubled younger sister, a suspicious last-minute trust amendment, a mother too sick to know what she was signing. He called Colette to the stand. She cried on cue. She said she just wanted what was fair, what their mother would have really wanted, if she'd been herself. Then he called Preston. Preston walked to the stand with the confident stride of a man who has never been told no in a courtroom, or possibly anywhere else. He was sworn in. He adjusted his tie. He looked at the judge with the professional warmth he probably used on nervous patients before knee replacements. Their lawyer asked him to describe his professional qualifications. He did, at length. Harvard, Mass General, board-certified orthopedic surgeon, 21 years of practice. He was asked whether he had formed a clinical opinion about my mental state during our mother's illness. He said he had. He described my symptoms: flat affect, intrusive caregiving behavior, irritability. He said he had been deeply concerned for my well-being. He said he had raised these concerns with my sister repeatedly, but that I had refused to seek help. He said, and here he looked directly at me, with something that was almost pity, that he hoped, whatever the outcome today, I would finally get the treatment I needed. My sister was openly weeping in the gallery. Priya stood up for cross. She is a small woman with a very soft voice, which is, I have come to believe, one of her most effective weapons. She walked to the lectern. She asked Dr. Keene very politely to confirm a few things. His specialty, orthopedic surgery. His training in psychiatry. A single rotation in medical school 24 years ago. The total number of psychiatric patients he had diagnosed or treated in his career. He paused. He said, I'm not sure I follow. Priya asked him again the number of psychiatric patients he had ever diagnosed or treated. He said none, in a formal capacity, but she asked whether he had ever conducted a formal psychiatric evaluation of me. He said he had not. She asked whether I had ever been his patient in any capacity. He said I had not. She asked whether he had reviewed any of my medical records before signing the affidavit attached to the petition. He said he had not had access to them. She asked how, then, he had arrived at a clinical opinion detailed enough to submit to a court under oath. He said after a pause that was a little too long, as a physician and as a member of the family, I felt I had a duty to. Priya interrupted, very softly. She said, Dr. Keene, you are aware, are you not, that diagnosing a patient you have not examined is a violation of the AMA Code of Medical Ethics? Preston's color changed. It was subtle, but I saw it. He said he had not issued a formal diagnosis. He had simply expressed concerns. Priya picked up his affidavit. She read aloud from it. In my clinical opinion, Adeline Holloway exhibits symptoms consistent with a mood disturbance of a bipolar or cyclothymic nature, and her capacity for reliable judgment during the final weeks of her mother's life should be considered significantly impaired. Priya set the paper down. She asked him to explain how that sentence was anything other than a formal clinical opinion submitted under oath about a person he had never examined. Preston did not have a good answer. Priya sat down. Then she stood back up, because we were not finished. She asked the court's permission to enter into evidence a series of documents she had prepared. The judge nodded. The bailiff distributed copies. I watched Colette's lawyer's face as he read. I watched my sister's as she looked over his shoulder. I watched Preston's, up there on the stand, as he realized what he was looking at. Priya walked him through it gently. The bank records, the wire transfers, the LLC, the second LLC, the third, the concierge medical practice with no patients, the jeweler, the yacht broker, the Nantucket contractor, the receipts, the timestamps, the cross-referenced surgical schedule that proved he had personally signed for a certified check on a day he had claimed, in a separate deposition, to have been in emergency surgery. She asked him very softly to explain to the court what Keen Family Wellness was. He said it was a wellness consultancy. She asked him to describe its clients. He said he could not disclose that information. She asked whether his late mother-in-law, Margaret Holloway, had been a client. He said he was not sure. Priya handed him a copy of an invoice. His signature was at the bottom. The invoice was for $38,000, billed to my mother's money market account for integrative oncology consultation services on a date when my mother had been in inpatient hospice care, and Preston, according to his own calendar, had been in Aruba. Judge Fitzwilliam had been quiet for a long time. He was leaning forward now, slightly, his elbows on the bench. He took off his glasses. He folded them. He set them down on the blotter in front of him. He looked at Preston. He looked at my sister. He looked at me. Then he looked back at Preston. He said, "Dr. Keen, you came into this courtroom today and swore under oath that your sister-in-law was mentally unfit. You signed an affidavit on hospital letterhead, making clinical claims about a person you have never examined. And it appears, from the evidence just entered, that during the period in which you were forming these so-called concerns, you were moving your dying mother-in-law's money into shell companies you control. Do I have that substantially correct?" The courtroom was perfectly silent. Preston opened his mouth. He closed it. Judge Fitzwilliam said, "I will take that as a yes." He turned to Colette's attorney. He said the petition was denied. He said the trust was to remain intact and administered to Adeline Holloway as the sole beneficiary, in accordance with the clearly documented wishes of the decedent. He said he was referring Dr. Keen's affidavit, along with the financial exhibits just entered, to the Rhode Island Attorney General's office for review, and that he was also forwarding the physician's conduct to the Rhode Island Board of Medical Licensure and Discipline. And, given the interstate wire activity, he was noting that federal authorities might also wish to take an interest. He said, "Court is adjourned." He picked up his glasses, put them back on, and walked out. I did not cry. I did not speak. Priya touched my elbow. Across the aisle, my sister was staring at her husband as though she had never seen him before. Preston was still sitting in the witness box, and he had the strangest expression, not anger, not even fear, just a kind of dawning blankness, like a man who has just discovered that the floor he has been standing on for 20 years is not actually a floor. I want to tell you that I felt triumphant. I didn't. I felt tired, in the same specific way I had felt tired the morning my mother died. I walked out of the courtroom and into the parking lot, and I sat in my car for a long time before I could turn the key. In the months that followed, things happened the way I had set them up to happen. The Attorney General opened a case. Preston was indicted on wire fraud and elder financial exploitation. The medical board suspended his license pending review and 8 months later revoked it permanently. The Nantucket guest cottage, it turned out, was not the only thing. There were other properties, other accounts, things Colette had never known about. She filed for divorce the week after the indictment came down. She kept the house in Providence. She did not, for a long time, call me. The money from my mother's trust is still mostly where it was. I didn't want to touch it. I used a small piece of it to pay off the mortgage on a little Cape-style house in East Greenwich, with a yard big enough for a garden, and I moved in with the cat my mother had left behind, a 17-year-old tortoiseshell named Beatrice. I did eventually take the trip to Kyoto. I brought my mother's reading glasses with me, in my carry-on, and I sat in a tea house in Gion on a cold afternoon, and I told her, quietly, that I had done it. I had gone. 11 months after the hearing, Colette called me. She was in her car, in a parking lot somewhere, and she had been crying. She said she had not known about any of it. About the accounts, about the shell companies, about what Preston had written about me. She said she had believed him when he said I was unwell. She said she was sorry. She said it over and over. I let her. I didn't say it was okay, because it wasn't, but I did say I would meet her for coffee next month in Warwick, near our mother's cemetery. We would go together and we would bring white roses, because our mother had loved white roses, and we would stand there for as long as we needed to. I don't know if we can be sisters again. Not the way we were when we were small and she braided my hair before school. I don't know if that version of us is ever coming back. But I know our mother would have wanted me to try. And I know that the thing I learned in those 5 months at my kitchen table with the bank statements and the red pen is that patience is not the same as forgiveness, and evidence is not the same as anger, and the quietest person in the room is very often the one who has been paying the closest attention. My name is Adeline Holloway. I am 31 years old. I buried my mother on a cold morning in March, and then I spent 5 months listening to people tell a courtroom that I was losing my mind. I wasn't. I was just counting.